Hello viewers, welcome to Ekam Academy. Today, as part of the concept of the day series, we are going to discuss about the important concept in terms of polity is president rule. So this is very common in Indian political context also. Almost since independence, more than 125 times in different states president rule was imposed. So what are the constitutional provisions related to president rule? In which situations president was forced to impose the president rule? We understand in this particular video. So first let us understand. There is also a term given for president rule, that is constitutional emergency. It is also called state emergency. So it was mentioned in Indian Constitution under Article 356. So what is the president rule? So whenever the state is not complying to constitutional provisions, or if there is a breakdown of constitutional failure in that particular state, then the President of India can impose president rule in that particular state. So this can happen on his own initiation, or that means on the aid and advice of the Council of Ministers at the center, or he can also impose president rule if the governor, who is the constitutional head of the state, feels there is a breakdown in the constitutional machinery in that particular state. He can report it to the president, because governor is generally the central agent also. So he has to ensure that constitutional compliance is there in the state government. So if that is not there, then he can also recommend the imposition of president rule. That means President of India on his own, or on the government or governor's report also, he can impose the president rule. So under Article 356. So under 356, there is also another ground. That means if the center has issued some guidelines, and if the state is not, or it has failed to comply those guidelines given by the center, in that situation also under 365, which is the article associated with this provision, under that particular provision, if it was not fulfilled, then under Article 356 also president rule can be imposed. So 355 empowers center to issue some directions or some instructions to the state, or it has a duty to protect all the states from any external aggression. So these things have to be taken care according to the constitutional provisions. But if any state is not complying the center's directions, or if it is going against the constitutional norms, then president rule can be imposed. So this is the first aspect. Then what will be the procedure? Generally, president rule can be imposed, we have seen already, on the president on his own, or by the report of the governor to the President of India. So once if it is imposed, then what happens? It has to be approved by Parliament within 6 months of time, provided that Lok Sabha is not in the state of meeting. That means if it is in the resolution, from the date of first sitting, within 1 month, that means 30 days, it has to approve. Meanwhile, Rajya Sabha also has to approve, because Rajya Sabha is always a permanent house. So that is the first thing. With what majority they have to approve? It is with simple majority. That means 50% of the present and voting. That is the majority required. First, it has mandated that it has to be approved in 2 months of time only. That means whenever the resolution for imposition of president rule is issued, within the 2 months of date only, it has to be generally approved by Parliament. But in case if Lok Sabha is not in the state of meeting, that means in the resolution stage, then within 6 months, okay, so it has to again reconstitute, right? So that means from the date of resitting or reconstitution, within 30 days of time, it has to approve. This is the first thing. Then second thing is, it has to be imposed, or it has to be periodically approved by both houses of Parliament for every 6 months with the same type of majority, that is simple majority. That means every 6 months, Parliament has to continue the existence of president rule in that particular state. This can happen only for a maximum of 3 years. For national emergency, there is no maximum period, but for president rule, maximum period of 3 years was imposed. But here, we have to understand, 44th Constitutional Amendment has further strictened this by mentioning beyond 1 year, if president rule has to be continued in a state, there has to be 2 conditions. One is, at least national emergency should be there in some part of the state or whole India. Otherwise, second situation is, Election Commission should certify that it is not feasible to conduct elections in that particular state at that point of time. Only if these 2 conditions are met, a president rule can be extended beyond 1 year to 3 years of time. Otherwise, it is not possible. Then, who can revoke? It can be revoked by President of India. For this, there is no parliamentary approval required. So this is what the procedure generally followed. But we also have to understand what will be the impact of president rule on center-state relations. So as the name it suggests, president will take the power, right? So that means instead of the state government, that means the Council of Ministers, who will be ruling in the name of the president, governor will run the state administration. So that is the main aspect. That means the Council of Ministers of that particular state gets dismissed. That is the main aspect we have to keep in mind. And the state legislature will be either dissolved, or it will be put under suspended animation, suspended or it will be dissolved. But mandatorily what happens is the Council of Ministers gets dissolved. That is the first aspect we have to understand. There won't be any change in the fundamental rights or the relations, how it will alter. Then second thing is President can assume all the powers and he can even delegate his powers to the Parliament. For example, he can ask the Parliament to make a law in the state list subjects. That is also one ground in which Parliament can make laws on stateless subjects. In 5 situations it can make, 1 situation is President rule. But President cannot assume the powers of the High Court in that particular state. This is one thing, right? So after understanding the change in relations, we have to understand what is the famous case associated with this President rule. It was S.R. Bommai versus Union of India case of 1994. This is a very important case which has totally changed the picture of the ground for imposition of President rule. So any ground like maladministration, corruption, bribery, these things cannot be a ground for imposition of President rule as stated by Supreme Court of India in S.R. Bommai versus Union of India case. They further said any violation of basic structure, like in case if there is any secular principle is not upheld by the state, if they are going anti-secular, then in that situation also that can be a ground. But on some grounds based on maladministration or charges of corruption, you cannot impose President rule in that particular state. So, but still, this was most misused provision in the Indian Constitution, which has to be used generally in a rare and exceptional situations only. Now, let us see the practice question for the day. Consider the following statements with reference to emergency provisions in the Constitution. 2 statements were given. Out of these, how many you feel correct? Let me know in the comment section. Then, today, as part of the concept of the day series, we have discussed about an important concept in polity is President rule. We have seen the constitutional provisions, what will be the procedure that will be followed, how it will alter center-state relations along with the practice question. So if you like the video, let me know in the comment section. Thanks for joining. See you again.